Good morning, everybody. There's a couple of things that are particularly clear at this moment. One is that we are between you and a refill of coffee. And the second is that there's been a lot of talk of foreign actors on that last panel. We're not foreign actors, but as you tune into our ear and our accents, which are usually reserved for the villains in Hollywood films. Well, we have infiltrated this summit. We've infiltrated the summit to tell you a little bit about what's going on in Europe. Jeanne, what's happening?
So, as you know, we're only allowed at a tech summit nowadays if you promise that you're going to talk about AI. So actually, we thought that for this session, we were going to bring you a little extra present from across the Atlantic. And that is an all-you-can-eat buffet of regulations on AI, but not only on AI.
Not only on AI. So we will talk about AI, we promise. But you have to zoom out a little bit when you look at the European situation just now. They're calling it the digital decade. Some of you in the room are following this, no doubt. I like to think of it as a tsunami of regulation that is hitting right now. I don't think there's been anything like it in give or take 25 years since the e-commerce directive and so on at the turn of the millennium. What are they doing? What's Europe up to? Well, there are four pillars standing behind this. One is to ensure that the citizen has digital skills. Secondly, that public services are digitized across Europe. Thirdly, that there is secure and sustainable infrastructure. And fourth, that businesses are digitally transformed. And it makes perfect sense. It's putting the citizen at the heart of everything that's going on in Europe. But in 15 minutes, we've got 15 minutes, Jeanne, why should you care about that? Jeanne, why should we care about that?
So as Mark said, the EU AI Act really has to be looked at not as just one silo regulation, but as part of a jigsaw puzzle of regulation. And this is important because this is not a selling point. This is the reality of how the regulation has been structured by the European Commission. And this is even not a selling point, is that if you're looking at the different texts that we have nowadays, they all cross-reference each other. And so whether it's about privacy, cyber resilience, AI, you have this really idea of everything that is intertwined. And I think it really echoes what we heard earlier, which is that, of course, you have AI, but to have good AI, you need to have good data. And to have good data, the EU decided to create what we call the Data Act and the Data Governance Act. You also need to have cyber resilience to make sure that your AI system is secure. And to do that, then we have DORA, which is a regulation, and the NIS2 directive. And then you also have to have an open and competitive market. And to do that, we chose to regulate again, and we have the DMA. So just to give you an example of how all of these different pieces actually fit together.
And they do fit together like a jigsaw puzzle, and the AI Act is just one part of that puzzle. And it's about riding the AI wave, right? Catching the wave correctly and making sure that you're out there and in front. But these things do overlap, don't they, Jeanne?
They do overlap. And if you're looking at the timeline, this is not something that you get to do tomorrow. This is something that you have to do today. This is not about putting it on the back burner. So if you're looking at the timeline of these different texts, so the NIS2 directive, actually, the date for the enforcement of the text was yesterday. DORA is going to be enforceable in January of 2025, as well as the first batch of the EU AI Act. So this is something that is pressing. This is a reality.
Okay, so you may be wondering at this moment, well done, Europe. Good stuff. Lots of bureaucracy, some nice red tape. Excellent. It's going to keep us busy for ages. And you might be thinking, why do I care about this in the US? It's a good question, actually. Why do you care about this in the US? Well, I've got a two, or maybe three, depending on how you write it, word answer to that. Extraterritorial effect. That's the problem that we're seeing, or the problem that you'll be facing when you look at these texts. What's that I hear you say? Let me explain extraterritorial effect with a few examples in terms of that might be relevant for you. So let's think about it. The AI Act is is trying to regulate and trying to reach you here in California. It regulates any AI system that is marketed in the EU and any AI system that is used in the EU. Marketed, used. Let's have a look at the marketed and used by way of example and see if that can make sense. Marketed in the EU. Okay, let's think of an example. You are a US HQ'd high-tech company here in the Valley. Not a stretch, right, for our audience. We can imagine that. Perhaps you are some sort of AI healthcare diagnostic. That's maybe the services you've got. You have subsidiaries. You've got a German subsidiary. Your German subsidiary is placing the AI product on the market in Euro speak, which means the US parent has to comply with the regulations. That may or may not be a surprise. Let's give another example. You're, again, another US company headquartered here. Maybe you've got some sort of AI-powered financial services advisory service. And you're beaming that, you're advertising that service directly to Europeans because it's on your website. Even though your HQ is here in California, you've got to comply with the AI Act because your services are targeted towards EU citizens. What about used in the EU? Let's have a look at an example there. Okay, again, another US headquartered company. You're in the food business. You've developed a very intelligent kitchen food blender. It's very clever. It's a bit of a machine. And this machine is advertised online. You offer it to customers around the world in the EU. The advertising counts as making available under the regulation because it could lead to a sale and then be used in the EU. So, making available, used in the EU, marketed in the EU. Is that it, Jeanne?
No, that's not it. It gets trickier. So even if you're a US company and that you're only using or deploying your AI system in the US, but if the output of the AI system is actually used within the European Union, then the EU legislator considers that it actually impacts EU citizens, and thus the EU AI Act applies as well. But so we're here in the Silicon Valley, and of course, a lot of you potentially are VC firms, and you're making investments in EU companies. And so you really need to have that extraterritorial effect in mind. And only yesterday, we were talking to a client, and they were saying they were just done this great round on fundraising. And some of the question they got via the due diligence was, what's your AI governance? What are the controls that you've implemented? What have you done to preempt the applicability of the EU AI Act? And that was for a US company raising funds in the US. So again, the extraterritorial effect is really there.
Okay, so have we done it? Have we convinced you all that you are actually European?
Yes. Congratulations.
And what's your reaction in the room here? Is it head in hands, or is it just business reality? I mean, there is a way of looking at this that perhaps this is a positive. At least we know what the rules are. Regulatory certainty is arguably a stimulus for innovation. We've seen that. We see that around the world. We've seen that recently, and some of my colleagues in the room have been working on the digital assets regulations, for example, in Dubai. That certainty is allowing organizations to thrive. And it does give, if you look at the positives, it does give a harmonized approach, at least to one large trading bloc. But Jeanne, how does it actually work in practice?
So how does that work in practice? So the EU AI Act is not about regulating the technology itself. The purpose of it is to regulate the use of the technology. So it's very much a risk-based approach, and it's use case per use case that you have to look at it. And so you have different regimes. And the risk is envisaged as on the basis of the risk for the individuals, on the basis of their fundamental rights. So there are some AI systems that if you're using them for a purpose that is deemed too risky, then they're going to be prohibited in the EU. And so what are examples of what is prohibited? So you have subliminal techniques, AI systems that use subliminal techniques to alter the behavior of individuals. But you also have biometric categorization AI systems, and so those are going to be prohibited. You also have high-risk AI systems. So what does that mean? It means that the risk is there, but that if you implement sufficient guardrails and checks and balances, you're going to be able to deploy and use them within the European Union. And then you have limited risk AI systems. Those limited risk AI systems are systems that, because they interact with individuals or generate content, the EU deems that there is a risk of confusion. And there is a risk of confusion because people could not understand that they're actually interacting with an AI system, or that a content has been generated by the AI system. It's exactly what General Mattis was saying earlier. You need to know that the content, that the voice of the person that he was mentioning was actually generated by AI. And so that's what the limited risk AI system actually category does. And then we were facing an issue, which was Gen AI. Gen AI is not for a particular purpose, of course. And so we needed to create a different category. And so for generative AI models and system, we have a specific category and specific obligations. So these are the different categories. How does that work now in practice? When you want to use a new AI system, or you want to create an AI system, the first thing you're going to ask yourself is this really an AI system? Everyone is saying, I have AI all the time, everywhere. But we now have a legal definition of what it is. So you get to determine whether you fall within that definition or not. Once you've ascertained that, the next step is going to be, what is my risk category? Am I high risk? Am I prohibited, etc.? And then you're going to look at who you are with the AI system. So are you the provider of this AI system? Have you created it? Are you just the deployer? So are you making it accessible to the public? Are you the importer or the distributor? And that qualification is going to tell you what are the obligations that are applicable to you.
Perfect. Okay, so we get that. So what's the definition? What's your risk profile? Who are you?
Yes.
Back to actors again. Who are you in the landscape? Okay. Unfortunately, we're not all European, are we? And there is an awful lot of other law around the world. In fact, if you're keeping up with it, the digital decade, as we said, but the new laws being published in China, Australia, and so forth, on and around the whole AI piece. And in fact, if you look at the OECD counter of regulation, draft regulation, new laws, consultancy papers, and so on and so forth, I think the latest number is 800 and counting. It's only going up around the world. So that's regulatory dissonance on a large scale when it comes to something global like AI. There's got to be some common themes here, Jeanne. How can we do this if we're a multinational?
So that is, of course, the important question for all of our clients. So how do you reconcile those different texts? And so the good news is that when you look at those 800 pieces of legislation, guidelines, and policies, you do identify some common grounds. And those common grounds are very similar, actually, to the OECD AI principles. And they're quite common sense when you think about it. So they're about, robustness, security, human oversight. So you can definitely create your governance across the globe around those big principles, and then identify the specificities that you have in different countries, and then apply those on a case-by-case basis. So in that sense, you can reconcile all the different pieces of legislation around these big principles, and that is good news, of course, for everyone in this room and for us as well, I guess.
And that reconciliation allows you to achieve RAI, right? Responsible AI deployment at speed, at scale. And in fact, on your apps, if you've got the app, you'll see our report, the Tech Index report that goes into the extent to which AI is being deployed around the world. We're seeing quite a lot of fear of missing out. Everyone thinks everyone else is doing it far quicker. We're seeing quite a lot of, my colleague in the room here calls the last mile problem. You can't just plonk an LLM, for example, on a massive law firm. There are some implications there. But we're seeing a lot of point-to-point solutions. But I think there's a bigger prize for business and society, perhaps. We're seeing, for example, in Canada, Brazil, and elsewhere, people looking at AI as solving some of the inequalities, perhaps social inequalities, perhaps access to justice, the rule of law, and so on and so forth. So as we wrap, we're going to wrap then, Jeanne.
We have 10 seconds.
We're not going to wrap. It is a wave of regulation. Yes, of course it is. But it can become, I think, if you're ahead of that wave, you're catching the wave properly. How am I doing with the wave analogy? It can become a compliance opportunity, as my friend Gareth sitting here always puts it. A compliance opportunity, two words that don't naturally go together, but getting ahead of the wave, we think you can turn this into a good thing.
So what are the key takeaways for this session? You have to really look at all of these regulations right now. This is, again, not something that you put on the back burner. You have to look at the global picture. It will save you time and it will save you money not to look at these texts in silos. The other point is that this is not about compliance, because you're never going to be 100% compliant. This is about governance. And finally, we think it can be an opportunity. We really thank you for your attention, and we hope you have a fantastic rest of the summit. Thank you.